Hey there, it's Tuesday. Eric Bland here on the Anything But Bland weekly update, and this is a bonus weekly update. I've always wanted to do this for the last couple years. I just haven't gotten around to it. And Saturday, when I was in Charleston speaking to the CLLA convention at the Francis Marion Hotel on the Murdaugh matters, and it was a legal ethics speech that I did or speaking engagement where I focused on what were the rules of professional conduct that were violated by Alex Murdaugh and Corey Fleming, just specifically in connection with the Gloria Satterfield estate. And I spoke for a good bit of time on it. And I went through the rule book, the rules of professional conduct. Lawyers are governed by the rules of professional conduct. And we take an oath that we're going to follow them, and they are evidence of negligence or malpractice. Violation of the rules does not automatically entitle you to a recovery, but they can be used to show a lawyer's violation of his duties or her duties to you. So oftentimes we bring civil suits against um, former lawyers for clients who violate the rules of professional conduct and also the standard of care. In this particular case, regarding the Satterfields and how Alex and Corey stole $4.3 million, which was recovered, 4,305,000 to be exactly, which was recovered as a result of Gloria's fall on the Mizell stairs, which occurred on February 2nd, 2018. And we all know she died on February 26th, 2018. And we all know that Alex uh, set up the Satterfields so that they would retain Corey Fleming, who would bring a claim against Alex and Maggie, and they would turn it over to their homeowners insurance carrier. They had a $500,000 policy with Lloyd's of London. Lloyd's of London usually does an umbrella policy or an excess policy to your homeowners. But in this case, they were primary for $505,000. $5,000 in the policy was medical pay. If you were injured, you get a medical pay recovery. And then Nautilus Insurance Company had a $5 million personal umbrella on top of it. So when we filed civil suit on this, we would obviously file for breach of fiduciary duty because a lawyer is a fiduciary to a client, owes the utmost of skill and expertise and unbridled, unfettered loyalty, zealous representation, can't put his or her interests over the client. We also filed conspiracy because obviously Alex and Corey made an agreement that harmed the client. The client was the estate of Gloria Satterfield. And so those are the type of civil claims that you would bring. And you would bring misappropriation and conversion and fraud because they obviously stole. When you stole, you convert other people's property into your own. Fraud is in South Carolina, you have nine-finger fraud. It's you have to show a representation was made, it was false, it was relied upon, it was the type of reliance that is reasonable and expected, that approximately caused damages and things of that nature. But specifically, the rules of professional conduct are very important because we are a self-governing profession. Lawyers have to govern themselves, and we have duties that we owe to each other. We have duties that we owe to the court. We have duties that we owe to non-clients, third parties, especially adversaries in litigation and adversary counsel. We take a civility oath, and obviously I've talked about that before. Jim Seidel has accused me of violating the civility oath when I called him a scumbag because he had taken my name and likeness, my picture, and inserted his book in my hands. I had a photo of me with my book, Anything But Bland, and he put his book in my hands. And um, so, you know, There are other rules, though, that govern lawyers' conduct. And I decided to just go down the rule book to see how many different rules that Alex and Corey violated in connection with representing the Satterfields. And you remember this all started at the funeral when Alex came up to the family. It was Tony Satterfield and Brian Harriet, along with Eric Harriet, Ginger's brother, and um, Gloria's brother, and then Ginger Hadwin, her sister, and Eric and Scott, and all these brothers and family members. And Alex said, "Look, this is my fault. Gloria fell as a result of my dogs jumping on her, and she fell back down the stairs." And we all know that he's the only one who heard that, because after they discovered, Maggie and Paul discovered Gloria at the bottom of the stairs, and she was bleeding and unconscious. Maggie didn't call 911 first. She called Alex, and Alex came running in his car at top speed from his law office. And supposedly he whispered, Gloria whispered in his ear when he asked her what happened. She said that the dog's fault caused the fall. He's the only one who heard that. And when she got to the hospital and was in and out of a coma for 3 weeks before she died, she wasn't able to answer any questions. So we had Alex's word on this. And obviously, if Gloria was coming to work, it would be a workers' compensation claim under our workers' compensation statutes in South Carolina. But Alex said that it was her day off when he reported it to his insurance company, and therefore it invoked potential recovery under his homeowner's insurance policy and his umbrella insurance policy. And just so everyone knows, if someone falls on your steps on your house, that doesn't mean that you automatically get sued. That doesn't mean that you owe them any enhanced duties, or you're going to be responsible for all their medical bills and damages and injuries. There has to be a negligence claim associated with it, that uh, your stairs were defective, they were disintegrating, or they were not built according to code, or there wasn't a proper railing on there, something of that nature. There were too many steps, or they were not, the risers were too tight. You have to have something of that nature. And in this case, the negligence was Alex's dogs were unrestrained, and supposedly they jumped on Gloria. There were 4 dogs, and she fell backwards, and God forbid, she died as a result of the fall. And so what Alex said is, "Look, I'm going to send you to a friend of mine named Corey Fleming, and he's going to agree to be your lawyer, and he's going to make a claim against me, and I'm going to turn it over to my insurance company, and then I'm going to hammer my insurance company to encourage them to settle, because I know your mother's medical bills are probably in the hundreds of thousands of dollars. They were in excess of $600,000. And as a result, uh, I'm going to tell them that they need to settle for the full amount of my liability policy. And hopefully we can pay off all of her medical bills. And there'll be, a couple $1,000 more, or a little bit more, for you, Tony, and you, Brian, as the sons of Gloria and her heirs, um, to recover some money on." What Alex didn't tell the Satterfields at the time was that Corey was more than just his best friend. He was his college roommate. He was godfather to one of Paul Alex's kids. Um, he had grown up with him. They had worked hand in glove many, many, many times together in different cases where there may have been multiple people injured in a car accident, and that he wasn't going to let Corey file a lawsuit against him. Um, and this is not proper, because, and we're going to get into the rules in a second, because Alex was encouraging a claim against himself and was the architect of this claim. Now, Corey Fleming, who agreed to do this, he has duties as well, obviously. He represents the personal representative of the estate, which would in this case, be Tony Satterfield. They determined at the funeral that Tony would be the personal representative of his mother's estate, which was perfectly fine. To become personal representative, though, you have to file paperwork with the probate court and you have to be appointed. Your lawyer is the one to do that paperwork. So in this particular case, Corey Fleming never met Brian Harriet nor Tony Satterfield. Never once talked to them on the phone, didn't have a fee agreement with them. Under Rule 1.5 of the Rules of Professional Conduct, fee agreements for a contingency fee. A contingency fee is the lawyer doesn't recover any money unless there is a settlement or a paid verdict or judgment. The lawyer will give his time or her time, and you don't have to pay an hourly fee. Hourly fee agreements do not have to be in writing under our rules of professional conduct, but contingency fee agreements do. And Corey was working on a contingency fee agreement. We know from this case that he took almost $700,000 from the $4.3 million that was recovered, and Alex got the rest. We know that, it was sent to a fake bank account named Forge to make it look like Forge Consulting out of Atlanta, even though it was sent to a P.O. box in Hampton. So Corey violated the first rule of conduct, which is fee agreements for contingency fees need to be in writing under Rule 1.5. Corey also violated Rule 1.4, which is a duty to communicate with your clients. You have an active duty to properly communicate with the client on what the scope of the representation is, what the goals are, and when things happen. Now, I can't argue with the competency of Corey because he recovered $4.3 million for Gloria's death. Now, Gloria was a wonderful woman. And as I have said many times, that amount was an extraordinary amount for a woman her age, and only based on the low hourly wage that the offending hourly wage that the Murdaughs were paying her to do her work. In Richland County, for instance, that case may have settled for $750,000 or $1 million, but certainly not $4.3 million. So Corey never communicated with his clients. He didn't copy them on any letters, emails. He only wrote one letter, which is extraordinary. But you have a duty to communicate material information in a timely manner, so that in the October of 2018, in October, he recovered $505,000. Now, he did not communicate with the Satterfields at that time, never told them that the case settled for $505,000. Obviously, Alex told Corey, don't tell the Satterfields. Now, here's where it gets really complicated, because now we move into a conflict of interest. Alex's law firm, Alex's paralegals are the ones who drafted the documents for Tony to become the personal representative of the estate. Now, I'll say that again. The defendant who the claim is made against to recover money on behalf of the Satterfields, he is the one who's drafting the documents. That should have been done by Corey. And Alex led the Satterfields, including Tony, including Brian, that he was their lawyer. Why? Because throughout 2018, he was shepherding the medical bills that were coming in as a result of Gloria stay in the hospital. He was collecting on a $10,000 life insurance policy that was in Gloria's name. He received a complaint from Bank of America when they were foreclosing on Brian's and the Gloria's mobile home that Brian was living in, and he didn't even answer it on behalf of them. He didn't even tell Tony or Brian or Gloria's brothers and sisters that she was going to lose her mobile home. The family was going to lose mobile home. It was only $17,000. and he had already stolen with Corey the entire $505,000 that was recovered in October. So there's an argument under South Carolina law that you represent the personal representative of the estates, and even though there's beneficiaries of that estate, your duties are only to the personal representative. Marani and I, my partner, argued a case before the Court of Appeals in the Ryder case where we think that lawyers owe duties to the estate itself and the beneficiaries because it's foreseeable that they're going to be able to recover under money that comes into the estate, the beneficiaries will. So throughout 2018, Tony is the personal representative of Gloria's estate. No communication is given to him through Corey Fleming, only through Alex. And in fact, in October, Tony faxes information to Alex saying about, hey, this is in connection with my mother's medical bills. They're trying to collect from me. Alex in his office and his paralegals, but mind you, don't tell Tony, hey, Tony, you can't contact us. We're an adverse party to you. You're the personal representative that ultimately could sue us for your mother's death. You need to contact your own attorney, Corey Fleming. They don't do that. They handle this communications that he gives them. And so Rule 1.2 talks about the scope of representation, and it's a lawyer's duty to give to the client the scope of what they're going to do. I'm going to write a demand letter, or I'm going to file a lawsuit if we can't settle it. Or in this particular case, I'm not going to sue my best friend. I'm going to do my best to try to get a recovery for you for your mother's death, but I'm not going to sue my best friend. That is it. The next thing is under diligence, Rule 1.3, a lawyer's duty is to be diligent. Diligent means timely. Diligent means to talk to your client, to tell your client what you're doing. And when things happen in that case, to inform the client in a timely manner, either by email, by phone call, by letter, copying your clients on letter, copying your clients on emails. This was not done by Corey Fleming. The second thing is you have a duty of confidentiality of information as a lawyer under Rule 1.6, that you can't share confidential information about your clients, about the matter with the other side. Well, in this particular case, Corey and Alex were working hand in glove. They're sharing information with each other about this claim. That violates Rule 1.6. Conflict of interest, Rule 1.8. Corey was operating in a conflict of interest because he owes 100% fidelity to the client, Tony Satterfield, and the estate. Can't put his own interests over theirs. Got to be single-minded on the client's behalf. But he's not. He's talking to Alex on the side about what are we going to do together when this money comes in if there's a settlement. That is a conflict of interest, an actual conflict of interest. And even though Alex is the target defendant in this case, he's assumed legal obligations and legal responsibilities, and his office and his paralegals have assumed legal obligations to Tony Satterfield as the PR, and they're operating in a conflict of interest. The next thing that happened is when the settlement came in for $505,000, and they didn't tell Tony or the family that there was a settlement, Corey and Alex got together and said, hey, let's get Tony out of the seat as being the PR for Gloria's estate. And let's name Chad Westendorf, who is the vice president of Palmetto State Bank. We all know that Alex had a hand-in-glove relationship with Russell Lafitte. Russell's in federal prison right now as a result of that. But Russell, he knew what was going on. He had been a conservator. He had been a personal representative for Alex in previous cases. We all know about the Plyler sisters. We represent the Plyler sisters, and Russell Lafitte was a conservator for them, and he plundered their accounts and borrowed money to pay off his line of credit from them at a low interest rate to pay off a 7.2% interest rate. He borrowed money to build himself a swimming pool, and he loaned Alex Murdaugh money out of their accounts. Clear, we knew all that took place, and that's why he is in prison. But if they named Chad Westendorf as the PR, he would be able to collect a fee, but all of the duties then would be from Corey to Chad Westendorf. And so they go to Tony. Alex goes to Tony, not Corey, his lawyer, but Alex, and says to Tony, hey, Tony, guess what? I think we're going to be coming into some money soon. And so we want to make sure that you can handle the business issues. Hey, Mary Ellen, excuse me for a second. Mary Ellen, can you tell them can we do the telephone call at 12:15? Thank you. Sorry. So Alex says to Tony, hey, there's going to be business issues, a little complicated. We're going to name a banker. He says, sure. So now the communications would be only from Corey to Chad Westendorf. So they renounce and revoke Tony's PR. And on December 18th, they named Chad Westendorf as PR. And the very next day, they go in and they make a motion to have Judge Mullen approve the settlement. We've already gone over Judge Mullen, that she didn't sign orders. They weren't filed. They had these settlement conferences back in chambers without a court reporter, and there wasn't everybody there, and there's no notes of it and no record of any of this. And in the court record, there's only one petition for a $500,000 settlement, and then the dismissal of the case. So they go in, Judge Mullen approves the settlement of $505,000. They never tell the Satterfields, and then they disperse the money contrary to what they informed the court that they would disperse it on. Corey Fleming charged like $5,000 in costs, and all he did was send a letter. There wasn't a lawsuit filing fee. There wasn't expert witnesses, depositions. In fact, the only costs that were ever incurred above that initial stamp was to John Austin, the mediator, when they settled for another $3.8 million in March. It was like a $2,700 bill. When that settled, they told Judge Mullen that there were $105,000 of expenses in a case where there was no case filed, no filing fee, no complaint, no depositions, no experts, no travel costs, no nothing. There is a duty of candor that you owe the court under Rule 3.3 that we can't lie to a judge. And Alex and Corey are appearing before Judge Mullen on December 18th and then again on May 13th to get the $3.8 million settlement approved. And they're lying to the court about how they're going to disperse the money. You have a duty under Rule 1.15 to safekeep the client's property. That means money that comes in, you have to hold in trust. It's the client's money. You have a duty to safekeep it. You can't just take it away. Partners have a duty to supervise each other. So Corey's partners at the Moss Coon law firm, Alex's partners at the Murdaugh Parker law firm, they had a duty to supervise when that money came in, how it was going to be dispersed, and that it should have been dispersed to court order. You have a duty under Rule 1.14 when you're representing a potential client that has diminished capacity. In this case, Brian Harriet has a little bit of diminished capacity. You have a duty to him not to take advantage of him. And obviously, Corey and Alex did in this particular matter. You have dishonesty and mismanagement under Rule 8.4D. Well, we have the dishonesty because they're stealing money. We have You have to maintain the integrity of the judicial system under rules 8.1 and 8.5. You can't do that when you start stealing money and you use the court's approval process on wrongful death settlements to enrich yourselves so that Corey can get his 700,000, Alex can get his 3.5 million. Alex is the defendant. He's not supposed to get any money whatsoever. So there's also the duty of pretrial publicity under Rule 3.6. And we all know that I've been had grievances filed against me by Dick Harpootlian and others about pretrial publicity. You can get on the microphone and go on the TV and go to the newspaper and talk about your client's case, so long as it's not going to prejudice an ongoing proceeding. There was no ongoing proceedings when I was talking to the press. There was no jury trial scheduled. I wasn't 1 month out from a jury trial where I'm trying to influence the jury pool. And you also have the right to correct a record. So if Dick Harpootlian or other lawyers are out there misstating facts or stating things that are wrong, you have a right to correct the narrative. You actually have a duty on behalf of your clients to correct the narrative. We all know that David Pasco and I reported Judge Mullen for her conduct, both in the first approval hearing on December 19th and then again on May 13th. In how she conducted it. She didn't file the order. She knows that they violated her court orders as a result of what we discovered. She's never tried to seek contempt sanctions against them. She's never on her own sua sponte, SUASPONTE, brought these parties in before the court and said, hey, you misled me. We don't know what happened with her complaints that we made, but we do know that she's still sitting on the bench. We all know about when she injected herself in the dispute in her neighborhood when somebody was trespassing on someone's property. She stopped her car. She encouraged a rookie police officer to take this mentally ill or drug-induced guy to a gas station where there was a restraining order against him. And she said, if you take him there, you can arrest him because he's not allowed on the property. And thankfully, the guy had body cam and reported this to his boss and stood up to Judge Mullen and said, Judge Mullen, this is not any of your jurisdiction. You're not involved. Please leave. We don't know what happened to that complaint. But we do know that all of these things happen, this criminal activity. I have had with my partner, Ronnie Richter, we've sued over 300 law firms in our career. We've sued the largest law firm in the country, Jones Day. We've sued every major law firm in our state, from Nelson Mullins to the Maynard Nexon firm that was, formerly Nexon Pruitt, now known as Maynard Nexon. We've sued the McNair firm, any firm that, we don't differentiate because we believe that lawyers put their pants on one leg at a time, just like everyone else, and they don't enjoy any special license. And why shouldn't we sue lawyers? We sue doctors, we sue accountants, bankers, engineers. So lawyers don't have any special license that they shouldn't be sued. And if they do something wrong, they should be held accountable. But I've never seen a case, and either is Ronnie, that two lawyers like Alex and Corey have blown through the rules of professional conduct and just absolutely, in the most egregious way, exploded it. When we were in law school, we were told if you do three things, you're going to lose your ticket. One of these three things. If you steal from a client, you're going to lose your ticket. If you lie to a client, you're going to lose your ticket. Or if you have sex with a client, you're going to lose your ticket. Well, these two lawyers did two of the three. It took a long time for Corey Fleming to lose his law license in this case. I had already shown to SLED when the charges were brought against Alex for Gloria Satterfield for the stealing of this money in October of 2021. They already knew, and I reported this to the bar. It's our practice when we file malpractice claims against lawyers that we automatically send a copy of our complaint to the bar. We're not trying to leverage the bar to have them bring proceedings to further civil action. That's not what we're doing. what we're doing is under rules 8.3 and 8.4, the duty to report. We as lawyers, when we observe or we come into knowledge of other lawyers violating the rules of professional conduct, we are duty bound to report the conduct to the bar. And that's what we did. So that's just a Whitman sampler of the violations that Corey and Alex did. And there's more. There's more that I could have dug deeper on subparts of these rules. But as you can see, it's extraordinary. And so when you are being represented by lawyers, make sure that you understand the rules of professional conduct. They're online. The South Carolina rules of professional conduct. They're based after the model rules of professional conduct, which govern lawyers all over the United States. And, when we take the bar exam, we have to take a substantive portion about the law, but there's a separate bar exam for the professional responsibility that you have to pass. It's very important. And you need to read these rules and say, hey, is my lawyer competent? Is my lawyer communicating with me in a timely manner? Is my lawyer being diligent? Pressing forward on my matter, or is it just sitting on his or her desk? Are they safekeeping my property? Or do we have a fee agreement if it's a contingent fee? Are they charging me, overcharging me for expenses that aren't related to this litigation? That's why this is very important. And so I appreciate you all listening. Money and Vision says, good to see you. Eric, good to see you too. Loving this. Thank you so much for explaining everything. Deanna Shower says he's truly a special kind of evil. And Diane McFarlane says, hi, you just made it. So I also sent out a newsletter last week, my first newsletter. It's called the Substack. It's going to be available to anybody that wants to subscribe for it. It's going to come out on a weekly basis, and it's kind of supplements the anything but bland weekly update that I usually do on a Wednesday, Thursday, or Friday. I got a big one I'm going to do this week. Lots of stuff on the Olympics and Major League Baseball, and Robert Duvall dying, who was just such an iconic actor. Jesse Jackson died this morning. Not a big fan of his, but certainly a historical figure. So be on the lookout for the Substack newsletter. We have a big announcement we're going to make about a subscription plan, about things that I'm going to do to educate all of you, not only on just current events, legal issues, but on legal questions that you may have, so that you can become a better informed client, that you can make demands of your attorney. Remember, the attorney works for you. You don't work for your client. You don't work for the attorney. This is a service business. We serve you. You are the client. It's your case. It's not the lawyer's case. So with that said, EB out. Talk to you guys soon. Thanks.